Good evening, everybody. It's October Surprise Part 2. My name's Brian Burke, and with me is my dear friend, attorney Sam Shihab. Hey, I'm an attorney too, but Sam, the October Visa Bulletin's out. Charles Oppenheim had his monthly chat with Charlie, and we're going to talk about it. We're going to have a lot of fun going in, reviewing what he said and what he said in the past as well. Right away, Sam, what's your take on Charles Oppenheim and what he has told us this week?
Well, surprise indeed. October retrogression, I've never heard of this, with 290,000 green cards available, the highest ever that you can remember, and you have retrogression.
Yeah.
It doesn't make sense. I guess it's a pandemic here. Nothing makes sense. And secondly, you don't know which Charles Oppenheim is going to show up. I think we have about 10 of them, or maybe there's a dozen of them out there. They come out and they tell you different things, different month. And I know he's sincere every time, but he's not consistent.
Yeah.
So that's my take on this. And let's break it down. Let's talk about the retrogression dates. Brian, what are these dates?
Yeah, I figure we'll just sort of show everybody what happened on the Visa Bulletin real quick first. So let's check out our presentation. There it is. There's the Visa Bulletin for the final action dates for October 2020. You know, those aren't such bad news. You know, there's been no movement either way on those. So it's October. October final action dates stay the same. Not too shabby in my book. But things get a little bit more interesting, as you alluded to, Sam, on the dates for filing. So in the dates for filing for EB3, we get a retrogression for India and China. 2 months for India, 6 months for China. But we actually get movement forward in EB2. So that's 7 months movement forward for India, none for China. But, you know, it's kind of a interesting surprise, especially after what Charles Oppenheim said last week about he kind of led us to believe there'd be very little EB2 movement, and we got quite a bit. But you know, so maybe it's kind of a wash if you look exactly at the Visa Bulletin, what it says on there. But things get a lot more interesting if you look at the fine print on the Visa Bulletin. And you know, there's my sum up. But here's what it is. What does it say? There's this bit of the Visa Bulletin that talks about movement of the Visa Bulletin in the future. And here's the mind blower. China and India, a retrogression of this date, the final action dates, could occur as early as November. Wow.
Does not make any sense.
I have to agree with you, Sam. I mean,
doesn't make any sense, but I think it's confusing, and I think it's like making sausage. I just don't see the rationale behind it, and I've listened to him, and we're going to be listening to clips of his presentation. And on one side, he talks about demand and inventory and terminologies that to us, we're trying to say, you know, I'm saying, Brian, what's that word mean? These are not legal terms. These are Charlie terms. And he uses them as he understands them, and trying to figure out why he moved it back. He moved it back because there's a lot of large cases filed. Why the EB2 is not moving as much is because the I-130, I-140s are not approved yet. So there's a lot of that stuff that's going on. We're going to try to explain to you his thoughts and his thinking pattern and what he said, trying to take it from our interpretation of what he said to English. I know he was speaking English, and I know he's done the best he can to make it clear. But, you know, we understand if you've listened to him and came out saying, what was he saying? Well, you're not alone. We sometimes have to stop and pause and listen to what he said and break it down. So it is interesting, but yes, 290,000 green cards and a retrogression.
Well, you know, I'd say, Sam, let's get into some clips then, see what Charlie was saying. And
we have about 6 or 7, maybe 8 key clips, and then we're gonna just run each one and just dissect it for you guys,
Yeah.
and then go from there.
Yeah, the first one we're going to go into, I think, is my favorite one. And it's technically speaking, it is from last month's chat, but it's really what Charlie said. It's something that really stuck with us, and we'll see what he said. Let's see what it was.
What are the chances that the India EB2 or EB3 final action dates will be retrogressed in fiscal year 22?
I attempt to control the forward movement of the final action dates in a manner which I can avoid any need to retrogress any of the established final action dates. And at this time, I do not expect the retrogression of any employment dates during fiscal 2022. If such action were required, it would not occur until much later in the fiscal year. Typically.
Well, Sam.
This is last month.
Yeah, this is from last month.
Not this month.
Not this month.
Okay.
But what is this month shown? The exact opposite of what Charlie said.
Yes.
It is. Oops, let me make you. There we are. It is retrogression in the beginning of the fiscal year, as early as November, and retrogression at all.
Yes. And further on, he says he's kind of alluding that he's maybe looking for more retrogression this year, as consistent with what he published.
Yeah. So
which Charlie are we talking to? I'd like to talk to last month's Charlie, who was more forgiving.
I like September Charlie. September Charlie made me feel good knowing that everybody's priority date was going to be, nobody was retrogressing. Good thing.
Yes.
I guess it goes saying that. I mean, we can go into what he's been saying this month. Any favorite clips you want to see, Sam, or shall I just?
In the order we decided to present them.
The order we decided to. That's a fair order, Sam.
Yep.
Here we are. Let's see what he said about why the EB3 dates for filing have been retrogressed.
In the September Visa Bulletin, the application dates for filing, which are listed for China and India EB3, were July 1st, 2019 and March 1st, 2014, respectively. But in the October Visa Bulletin, the dates for filing for China and India EB3 were moved back to January 15th, 2019 and January 8th, 2014, respectively. Why did you move these two application dates backwards?
Each month before I'm making the determination of the final action dates and the application dates, I consult with the USCIS officials, and their inventory projections show that on October 1st of 2021, coming up, the pending demand, which both state and USCIS has in the employment third preference for applicants born in India and China, will already exceed the amount of numbers that are available to applicants from those countries throughout fiscal 2022 in the third preference category. And therefore, for that reason, we made the decision to retrogress those application dates for filing, to limit new applications, which we did not at the time anticipate could be processed during fiscal 2022. But
I need to understand inventory projections. I mean, these are not legal words. These are not in the regulations. Inventory projection, one word he used, big word. Second one is pending demands. He did not use minimize filing, but he used it down. He said limit new applications. So 3 words he used are big words. Inventory projection. I'm looking at my screen here because I have to type them down because these are words I'm not used to them. Pending demands equal limit new application. That's from what? From October of last year's filing. It is a year later. Now they figured out they have a lot of applications. How long it took them?
I mean, that's something that, I don't know. Can they really not predict that those EB2 folks who are in a backlog for a decade aren't going to go into EB3?
But they did it a long time ago.
Yeah.
They're in the pipeline forever.
I mean, you're right. They don't. I mean, it's not even. They don't have to project anymore. Those cases are in USCIS hands right now.
Yeah. So inventory projection. I think this is. I mean, I'm trying to understand what inventory projection mean, because he said USCIS looked at their inventory projection. So now this is a big word, right? When you say big word, you say, okay, I'm stupid. I don't understand what they say, and therefore I must not question what that means. No, we're smart people, and we're going to break it down. Inventory projection. So for me, inventory projection, if you're in a warehouse, is what's in the warehouse now and what you're going to get, right? Okay, because the word projection and inventory a little bit are inconsistent, because inventory is stuff.
What you have.
Projection is things you're gonna have. Yeah, it really doesn't make sense. So okay, no problem, we'll accept it. So it means inventory in the future, right?
Yeah.
During the year. So did they not have the inventory in the projection from for the last 6 or 7 months?
Well, the bottom line is he says, oh, we got to we're rolling back the filing dates now because we have enough cases in our inventory projections to cover the entire fiscal year 2022, more or less, right?
And they have 290,000 green cards.
Yeah. 290,000 green cards, and already enough in their inventory, presumably cases in their hands to file them, to cover that.
Here's what I am filling in the gap. And I'm not putting words in his mouth, but I am extrapolating. I think he's also calculating that USCIS is not going to process all these cases. But he's not saying it, because the moment he says it, well, I'm also considering that 190,000 of the 290,000 will not be touched, because down the road in the video somewhere, I'm not sure it's on the list of videos we're going to play, he said USCIS is doing a fantastic job. They're approving 7,000 cases a month.
That means they're on track to do about as many as they do in a given year. You know,
7. So I have an engineering degree, and I can add 1 + 1, right? I think engineers do a lot more than that. But what's 7 times 12 is what?
Sam, I have a degree in literature. I definitely cannot trust myself to say the answer to that aloud.
Well, it's less than 100,000. I don't have to, So there's 190,000. So if they're doing 7 to 10,000 cases a month, they're on track. They're on track to waste 190,000.
Again, yeah.
And I think that is the retrogression.
Yeah.
But
I must point out, Sam, I mean, we know that USCIS has recently ramped up due to the closing of the fiscal year to get to that sort of, high volume. They do work faster towards the end of the fiscal year, your August and Septembers. Can they really maintain that breakneck speed that Charlie's so happy about? I'm using the quote signs. You can't see them.
They're doing a great job.
Yeah. I mean, can they really do a great job for the entire next fiscal year to keep up that pace? Or is it going to be a situation where they only get truly fast at the end of the year?
So if a great job is wasting 190,000 green cards, I'm afraid to ask what would be a mediocre job. Because that for me is a scary thought. If you're doing an A+ job and you're wiping out 200,000 green cards and not able to get to them, that's a little bit of a problem for me. I'm scared. But
let's go on. Let's see what Charlie says about how much retrogression is expected, which he doesn't give a straight answer to, but he gives us an answer for sure.
Next question, in the projections of visa availability in the coming months, you mentioned that some of the retrogression of the employment final action dates could occur as early as November. Would such retrogressions be in months or years?
At this time, I can't really estimate how much the employment retrogressions may be or how soon they will occur. I just wanted to alert all the viewers and readers of the Visa Bulletin that the retrogression was a potential action. We, at the beginning of October, I will make a review of the amount of demand that we have in-house and immigration service demand, which is expected to reach us in the near future. So again, I will monitor USCIS use of the numbers to determine when it's going to actually be necessary for the retrogression. And should a retrogression be required, the goal is always to have them be a one-time retrogression to minimize future use, but still have the potential for forward movement at a certain point later in the year if the current level of demand were to subside and allow such movement. Another consideration is that there could be legislative action which may impact the fiscal 2022 annual limits, and such potential action would be considered before any corrective action would be taken.
Well, Charlie can't tell us how much retrogression, but he's, it's interesting that it's on his mind that there's potential for the legislative action to impact what that retrogression is. So he does. A couple of months ago, Sam, Charlie said, I can't comment on that. The very idea, I can't comment that until it's on my plate. But then he's talking about, but I have to take into account. I will be taking into account that legislative action. Maybe he's talking about something when it passes. It sounds like he has something in mind, doesn't it?
There's no question. That's my conclusion. I think he's on the inside track.
Yeah,
no question. So for me, it would appear that he believes that there will be legislative action this year. For him, he is probably talking to Democrats, he's talking to Republicans, he's talking to sources, and he feels, because that's his business, that there will be corrective action. Now,
that's good. I love that.
Well, wait a minute. The question is the corrective action in favor of employment immigration, or is it not in favor of employment immigration? And if you played that piece few more seconds, he was talking about that video. He was talking about, I don't know what to do here, because if this legislation comes late in the year and it is not favorable, I have to retrogress aggressively back.
Yeah.
And if it's favorable, I have to move aggressively forward. And I don't know how to do it. So the later the legislative correction, the more aggressive my movement will be during the year. When he talks about retrogression and moving forward, and again, man, I shouldn't be reading him. I think he is probably thinking it's going to be favorable to employment. It's just my interpretation.
I want it to be favorable. I want it to be favorable to everybody. But when I think it just, how we've gotten here is that the family-based visas have rolled over into the employment categories. I can't help but think that whatever legislative policy is going to try to give, I sympathize for the family-based cases as well. They've been totally cut out of visas for the most part, because they mostly get issued to the consulates. They've been cut out for the last year and a half. And I can't help but think that some of those visas have to go back to them. And that means if they're going to them, Sam, they're not going to the employment categories. They're not being rolled over into it.
Well, the law, by the way, allows to roll back to family again under a certain calculation scenario that it does not usually happen, and therefore they end up being wasted. So the roll is circular, but the way it's calculated into the family, back to the family immigration, is such that it will never happen. It will get wasted. Just a stupid mathematical calculation that I wasted 2 hours figuring out one time, and I don't want to do it again because it's a waste of my time. But be that as it may, it's unpredictable. I mean, what is it in October? What is this year? Unpredictable. And then you will probably get into the future clips, and I don't want to talk about the future ones, but maybe we should roll the next one.
Yeah, let's go. Somebody asked a really, really great question. It's essentially, hey, there's so many people from India and China eligible both in EB2 and EB3. Why can't you give sort of a joint estimate as to how those dates will move? And this is one of the later questions that he brings up, and I thought the answer was pretty darn interesting. Let's see what we got here.
All right, a couple more questions. A lot of Indian applicants are eligible for both EB2 and EB3. Can you provide estimates for demands considered together so that people don't need to jump lines unnecessarily?
I can't do so because I don't receive information in terms of the amount of applicants, say, that are downgrading or upgrading to a specific category. The reason being that information really wouldn't be too relevant to my decision making because I don't know how long it would take for such action to occur. So knowing that, for example, knowing that there's a lot of applicants downgrading to a third preference category, say downgrading to Philippine third preference, I wouldn't want to retrogress the Philippine third preference date on the assumption that those applicants are going to be downgraded in the near future. It would be better to wait because the approval of the downgrade may not occur. So I would not want to have taken an action which may have been otherwise unnecessary.
So he doesn't want to act on cases that he doesn't, not taking into account cases that he doesn't know the result on, whether they're going to be approved.
Well, he said I can't tell the future.
Yeah.
You know what people's going to do, but that was not the question. The question is, can you give a combined, we're going to be moving 200,000, 50,000, 8,000 EB2 and EB3, or something like that. And he's not asking you to predict and project, but there has to be a better mechanism to avoid the movement of the water left and right, opposite of the inertia, because that's what you got. You got movement to the right, and then the water goes to the left, and then movement to the left, and the water goes to the right, and that is inefficient. And there has to be a better way. And the problem, of course, you may have those on the clips going forward, is when he says, I can't do it because I don't have information. Well, you should have information. You should demand information to do a better job. Right now, he's transparent. I love it. We're over this now. Now, through the transparency, we see problems. We see a system of calculation that doesn't work. It really does not.
Yeah, he says that he can't take into account, those the downgrade cases that aren't approved. It creates that back and forth. Everybody just now rushed into the EB3 category, and now EB2, as we saw the dates earlier, the dates for filing for EB2 moved up a ton, and it's just going to go. Then that's going to prompt people to, like you said, wish-wash back and forth, move from category to category, and as a practical matter, Sam, most of these downgrade filings, the I-140 case is based upon the same essential facts as the original I-140. Now, some of these cases I do concede won't be approved, but how do you feel about the vast majority of I-140 downgrades, Sam?
Well, you don't have to say the vast majority. You don't have to do that. You're trying to move priority date. You are extremely safe saying 50% will be approved.
Yeah. I'd be thrilled with that.
I know that probably 90% will be approved.
Yeah.
Right? Or 85% will be approved. But you can say, I am a government official. They filed, 200,000 downgrade. I'm going to open up 100,000 EB2s. I don't know if you have that clip that he explained again, how he calculates. Is that on your list?
The straw metaphor?
No, the one that he explained exactly how he moves the I-140 EB3s but does not move it. He was asked again, and I can paraphrase. He was asked again, how do you move the downgrades? How do you go about moving the downgrade? And he went in full details and said, if there is an I-140 petition downgrade filed, okay, USCIS allocates a number for it. He gets a report reserving a number for the EB3 downgrade. Then he proceeded to say that he does not release an EB2 for that person until the EB3 for that person is approved. And only when the EB3 is approved, he then will get a report releasing the EB2. Well, the timeline between the downgrade and the approval of the EB3 I-140 is 6, 7, 8 months. You are holding a number hostage, the visa number hostage, for practically almost an entire fiscal year or 3/4 of a fiscal year. And then you're releasing it when it's too late to even act on it. Because obviously we're going to have wastage, we're going to have even more wastage because you're not moving the dates for people to file. So again, how can you hold, I mean, if there's 200,000 I-140 downgrades, and let's assume right now 40% of them got approved, there's about 120,000 spots are held up in that downgrade process because the I-140 EB3 is not approved yet. I'm going to say 100,000 held up. And now that's held up, what incentive does USCIS to approve these cases? Because every case they approve, they'll get another case in the EB2. So might as well work on the case that's current for somebody else.
Yeah.
All right, next clip.
So I think we have what I think is your favorite clip, the
straw clip.
Charles and the Giant Straw. Sounds like a good children's book. Let's check it out.
First, why, for advancing the dates, did you not consider processing speed of USCIS, but for retrogressing, you are considering the processing speed of the consulates?
Well, I'm considering, I know the amount of demand that is pending at our consulates. For example, Mumbai, how many potential third preference cases that they have to process in the coming months. If they were to resume final action on cases. So I have to consider that somewhat, but it is not a huge concern, but I do know that it would add to the demand that I already know that is out there for the USCIS offices. So Mumbai coming back online is only going to accentuate the quote problem with visa availability for India third preference applicants. In terms of moving the dates forward, I think you've answered your own question. If USCIS is not able to process, say, for example, employment cases at the rate you would expect or like, then moving the dates at a faster pace is not going to make any difference. It's kind of like, only a certain amount of water can go through a straw, depending how regardless of how much water you try to pour down it. So, and if we had moved the final action dates at a faster pace, it would, although it would not have resulted in more number use at the time, it could have resulted in applicants, say, assembling documentation or doing things which then in the meantime, if, as there will be a retrogression or something, could, kind of negate their efforts in assembling documents.
Well, Sam,
I'd like to be in this too.
So say your piece on the subject of the straw.
So he's saying that, he's looking at the bottom of the straw, and he said that doesn't matter how much water you put in the straw.
Only
It's
so many cases can go through the straw.
approved.
Yeah.
But if you have a longer straw, really long straw, you can be inside the straw, meaning an adjustment, and that's really a cozy place to be in. And he doesn't see it. He's needle focused on the tip of the straw, where he needs to look at the whole straw.
Yeah, I can think of many people who aren't in the straw and would love to be in the straw. I mean,
I
he
think
says
we all need to send him a tweet asking him to please make the straw longer. We would like to be in the straw. Mr.
Sam, I think tweets should be funny. So I just want to take a picture of him and just Photoshop it at him with a ginormous twisty straw, just sucking things up. I mean, she makes a good point. He says, if I had moved the dates faster, there was no way, if I moved the dates further, the filing dates further, we can only approve so many cases. We're bound by the law as to how many cases we approved. Fine, but you could have picked up more cases, getting more people in process. And I mean, nobody wants to be stuck with a pending adjustment of status for 5 years. But it's a lot better to have a pending adjustment of status than no pending adjustment of status at all.
And again, I repeat something I said earlier. If you carefully listen to this piece, he said, "What benefit would it be to move the case forward if USCIS cannot get into these numbers?" Therefore, he is definitely putting in consideration the amount of wastage that is expected this year, but for any legislative relief in his numbers, and he shouldn't.
Yeah,
that is not something that he should consider. He should open it up, and he should say, you know what? I got 290,000 green cards, USCIS. I'm sorry, you're going to have 290,000 files. And if you waste them at the end of the year, those guys sit in adjustment until you get to them. 8 years, 9 years, but these guys can open their businesses. These guys can transfer. These guys can have some security. They can get better jobs.
I mean, part of his perspective,
go to school.
Part of his perspective might be that he's a Department of State guy, and Department of State, they essentially hand out green cards more or less through the consulate, and then somebody enters the United States as a permanent resident, and he's not really entrenched in the USCIS process, where somebody waits for a decade here and is, would love to have. He's not so familiar with the interim benefits of having a pending adjustment of status.
I would 100% agree with you, but for that this man is a top level official.
I know.
Who's highly intelligent, and he knows. I'm sorry, he knows. He's smart. He knows that he lived the 2007.
Yeah.
Everything current, and the fact that a lot of people stayed in adjustment for a long time. But it's not fun, but it's a heck of a lot better than being on the H-1B.
Yeah. Yeah, I mean, I think the long and short of it is, I think there's a lot of people out there who could live with a pending adjustment of status and understand, I guess, can understand the existence of a backlog. But why should you have to wait 10 years to file that green card? I mean, in my perfect world, if we have to have a backlog for actual green card availability, let people get those interim benefits as soon as they're eligible, their I-140 is approved, and just let them hang out and live that not quite a permanent resident lifestyle for. I mean,
what Charlie needs to do next, because he's a man that believes in transparency, is dump all that data, all these calculations, okay, and post it for public review.
Yeah, I would like to be a fly on the wall during his monthly USCIS meeting.
There's files and numbers and data and calculations and spreadsheets and notes that all needs to be dumped out in the public. And I'd love my Chinese and Indian and Filipino and European ITs and friends crunch these numbers and educate Charlie and help him for free.
Because I don't know, Sam, it sounds kind of like a FOIA request.
Sounds like a FOIA request. Yeah, they'll probably go in the. Yeah, absolutely. I'd like to do that. That's a great idea. Make note of that, Brian. We should foil his work, and that we should probably get.
I want to know what comes out of one of these meetings, because again, I mean, the whole theme of what we talked about so far is the very first clip I played was Charles Oppenheim in September saying, no retrogression. I don't anticipate any retrogression during fiscal year 2022. And even if there was, it would be at the end of the year. And now we are a month later, and he says retrogression forthcoming at the beginning of the year.
And or I've already retrogressed a little bit, and I'm going to retrogress more.
Yeah.
And even there may be even more down the road. And
yeah.
The 290,000 were used, but then he says, what benefit would I do if USCIS cannot get to those cases to move the date forward? So I don't know. Disappointing for sure. You got any more videos?
I have a couple more. I mean, I hit the ones. You know, we also want to get to some questions, Sam.
Yeah,
so I hit the ones that I thought were the best ones. Is there anything you really missed that you wanted to see?
Well, the one explaining the calculations is something that I really would love to have seen.
I'm terribly sorry. I can't. my notes aren't clear enough to. I don't have him transcribed word for word. I'm afraid.
Yes. Yeah, it's I think my first email to you on the video links.
I can check that email and probably get a link going to it for us real quick if you'd like to see it.
Well, no, let's get going with questions.
Okay, let's check out some questions. Let's see what we got. So I'll read it. This is from Syed. Hi, Sam and Brian. Good to see you guys again. Good to have you watching us. My priority date is November 2012, EB2 India. I postponed my decision to downgrade to EB3 when I see October Visa Bulletin. Now I'm thinking my priority date will be current in the coming 6 months. Well, you know, I'm gonna go ahead and sneakily look at my PowerPoint presentation here where I had the Visa Bulletin. I mean, your dates for filing for EB2, India, July 8th, 2012. So based upon your date of November 2012, yeah, it's moving. It's definitely moving. And every time an EB3
depends on which Charlie shows up.
Well, you know, I've been saying this for months, Sam. You obviously have to. You must agree with me, Sam. When they approve these EB3 downgrades, they have to move they pluck people out of the EB2 backlog. They push them out of the queue altogether, and they free up that EB2 number, and thereby the EB2 numbers have to move forward. And we're finally seeing it.
Well, how many I-140s by percentage have moved in the last year? 40%, 50% of the cases?
The downgrades, you mean?
Yeah.
I don't know.
30%. A lot of premium processing.
I'd give it maybe a 50%. I feel like in the last couple, I mean, I talked to a lot of people about, Brian, when are they going to improve my green card? I feel like I'm not talking to as many people about, you know, your I-140s not being approved as your impediment. Now the impediment now is getting USCIS to pick up the case and make a decision on your I-45. It's on most cases. What do you think? So you think about 40?
Well, I'm just helping you out here projecting, because if that movement is practically filling the gap of 50% of the I-140s, so you're going to move another 6 months. We moved 6 months for 50% of the downgrade, so there'll be another 50% movement, which is another 6 months probably this year sometime. So I would anticipate that we'll get to that date this year sometime.
Yeah. So I mean, really, I think, you know, one of the things we talked about, Sam, on past presentations is you know, why not file an EB2 adjustment just because you can? If you're the sort of person who just wants to be, you know, ride both lines and take whatever, you know, one option is to basically have an I-140, you have an I-140 EB2, you have an I-140 EB3. USCIS will take an adjustment in the EB2 category. They'll take an adjustment in the EB3 category. You file 2 adjustments, and all you got to do is wait for them, whatever date gets current first.
Well, that is the only way to do it with the way they calculate dates. Yeah,
based upon the back and forth we're seeing, you know.
That's the only way to do it. I mean, you know, I know it costs a little bit of money, but that's the only way to do it, in my opinion. And don't do your entire family. You can do filing to join.
That's true.
You can do filing to join, or you can file new adjustment for them because you've got yours in, and then they will be will be fine as long as you get your green card, right?
Yeah. So
only one case and file for one adjustment, and that's not very costly to do.
Yeah. So let's see what we got. More questions. This is from Callion. So case stuck at fingerprint received. I emailed my senator and he told me the case is at the field office, and Emma told me it's at the service center. Do you know who's more trustworthy? That's a fun question. Sam, who's more trustworthy? Your senator's office or Emma, the USCIS online chat service?
I would say the senator.
I would agree.
Yeah, I would say the senator is going to be more trusted than Emma, in my opinion.
Yeah, I mean, and I like, in terms of.
And his information is good as the liaison person at the service center, because if the liaison person just made up something and gave it to the senator to get rid of the phone call, then that's what you got.
Well, I like the idea of a case being at a field office because, my take is, field offices are what usually the people who make the final decisions on adjustment of status processes. And we did hear a while back that USCIS was moving cases to field offices away from service centers, so those folks, could do this. So I like the idea of a case at a field office. Any movement in your case is good in my book. You're getting notices on your case. You're getting an RFE on your case. You're even getting an interview notice on your case. I like that better than nothing at all,
I agree.
Next question here. So my I-140 EB2 is approved with the priority date of June 2018. If you were me, will you apply for an EB3 I-140 right now, just in case is better, or just stay put?
Stay put. 2018 is a long way to come.
Yeah. I mean, it doesn't hurt to have an EB. I mean, if your employer is willing, you can have 2 I-140 approvals, but don't go rushing right now because that priority date is not coming up anytime soon, unfortunately. I'm sorry to say.
Only advantage, sorry, Brian. The only advantage of filing up a I-140 now and getting that out of the way is the financial ability. The more you wait,
that's a great point.
The longer time of financial ability you have to prove. Like, for example, if your perm filed 10 years ago and you got an I-140 EB2 I-140 10 years ago, and now you're filing a second I-140, just by way of example, you legally have to prove financial ability for 10 consecutive years.
Yeah.
And that's consecutive years of financial information the employer has to give, which is burdensome as heck for the attorney and for the client, for you, and risky.
Yeah, those RFEs are coming. I mean, that's just not in theory. We're seeing those RFEs fairly often. I mean, so that's good news that USCIS is processing these I-140s, but we are seeing more we're seeing I-140 RFEs saying, okay, employer, we want 10 years of W-2s for this person and tax returns for you to show that you have the funds. I've always had the funds available to pay that green card wage.
And also, I mean, the thing that I'd like to kind of stress for everybody is, I know you're trying to go through this case in a cost-effective way, but if there's money to be spent right now for you, it is really on your green card process and beefing up the green card process. You can, $1,000. That's a weekend vacation somewhere. Skip that. Get that out of the way. Get the I-140. Get the I-485 if you can get another one in. Like yourself, close the gaps. We got government officials one day coming out and say, I don't see any retrogression in the whole year. And then 30 days later, sorry, I retrogressed it now. I'm going to retrogress it next month. I'm going to retrogress again a few months later. We don't know. I mean, he's doing the best he can. And I repeat that because I really like him.
Yeah.
The matter is, garbage in, garbage out.
Yeah.
He gets information from USCIS. He acts on information from USCIS. USCIS doesn't give him everything. He has no clue how to release the I-140 and EB2. He has no clue that there was a zillion downgrades until 6 months later. And he gets reports, and based on these reports, he acts. And then when he's giving information next month, something different, he changes his path. And you're bouncing with him. It's like, oh, I'm going to get it. Oh, no. Just file on both sides and just let it go.
Yeah. I mean, for peace of, but it's funny. Charles said, don't listen to anybody. Don't read a blog. Don't read any other predictions out there. I'm the guy with the best information on this. And he, I guess in theory he does. He has the ear of USCIS, but I mean, the way just the change for this last month versus this month. I'm going to retire from the predictions game, Sam, because if he has the best data, and this is what we get on the Visa Bulletin.
Charlie, you got the best data, but you do not have good enough data.
Yeah, I get that's a fair assessment. Yeah.
Yeah, you just don't have good enough data to make good enough decisions to move us through this process.
Yeah.
And move the priority date forward. Get people file their adjustment. It's safer for them. Understand that being an adjustment is at 10 times. These people have been here from China and India, generation almost. You know? And get them in the adjustment. Get them on the EAD. Let them have the flexibility and the security of being in the straw. Put them in the straw, please.
Sam, I was literally talking to somebody this morning. He said in passing, well, worst case scenario, my son's 6 right now. Give it 15, 20 years. He can 15 years. He can petition for me, and that just depressed me as an immigration lawyer. I said, oh, these are the solutions. This is how our immigration system works. It's not fun.
Unless they change it by then.
Unless they change, and that's kind of what we have to look forward to. I mean, changing the way they accept green card cases, Sam. Let everybody get in the straw. In Charlie's big straw. I mean, it's not a perfect solution, but it'll make people's lives a heck of a lot better.
Charlie, we would like to be in the straw. That's basically the bottom line. Next question.
Let's see what else we got here. So, Sam and Brian, how positive are you that the current planned immigration bill will pass in the Senate? And if it passes with modification, do you think employment category will benefit from it?
We just talked about that. It's really, I mean, my God, who can figure this one out? It'll be a millionaire. I mean, I'd like to be in the futures of figuring out the congressional bills, but it looks like the appetite is there to fix it on both sides. And listening to Charlie today, he seems to feel that it is coming.
Yeah, a couple of months ago, he said, "Oh, I can't. I'm not even going to read these things." And now he's thinking about, I'm going to be taking that into account.
Yeah, and I'm reading that there has been some deeper analysis of certain bills, the Eagle Act. They're starting, to dissect it closer. So I think there may be something happening. But for me to say, "Oh yeah, it's going to pass," then I'll be very dishonest with everybody. I have no idea.
My perpetual joke is, "Oh yeah, that'll pass. All it requires is the Republicans and the Democrats to agree on something."
Not even Nancy Pelosi will figure that one out until it's voted on. Yeah, but we'll see.
Let's keep on going. So the final action date hasn't retrogressed yet, though. Correct. The wording retrogression as early as November would also be because of the reconciliation bill making its way. So as to bills making their way, but yes, the final action date hasn't retrogressed yet. The very first thing we hated came in late was, what the October Visa Bulletin looks like. The final action dates stay the same, but the dates for filing, the EB3 dates, mostly for India, rolled back, and the EB2 dates move forward. So it is interesting times. In the last year, we had a great big rush forward in EB3, and now, to use Sam's, wave metaphor, we're seeing it kind of flop back over to EB2 as people get approved and yanked out of the EB2 category into EB3.
Yes, indeed. The focus right now on the filing date, because USCIS will be adopting, or maybe have already adopted. I'm going to see, did they publish that? The filing date. But that's we'll see what happens after that.
Yeah. So going to keep on moving it on here. Hi, Sam. I already have a green card. And will work in an IT company from 8 a.m. to 5 p.m. If I work another IT full-time job from 8 a.m. to 5 p.m. at the same time, does it cause issues with your USCIS or IRS in the future? Thanks. It causes problems with your sleep schedule. It causes problems.
You can do that. I'm assuming you're working at home and you're just well, outside immigration law, unless there's full disclosure with these two companies, you may get in trouble.
Yeah, I mean, just like contractually, you might have an employment contract that says you're supposed to devote your full time and efforts to it.
I don't think there has to be an employment contract. If he's employed full time, he's expected under common law to dedicate the time for that employer. Now, you could be an independent contractor. I don't know on the other job, but if you're independent contractor on the other job, I mean, there has to be full disclosure. I know that happens a lot, by the way. This is something we hear a lot. Because you're like in support or working remotely, obviously, it is not 100% okay. You could get in trouble for doing that. Now, you asked me that question. Obviously, you asked me immigration law question. Brian, take that one.
Yeah, USCIS and IRS. USCIS, you're a green card holder. You can work for whoever you want on whatever. You can work for whoever you want. There you go. They don't care if you're working yourself ragged. You're a green card holder. You're free to do what you want. IRS, disclose your income. They're happy campers. Again, you're allowed to work as much as you want. But I mean, my brain jumped to the same spot as Sam's did immediately. It's not in our usual purview as immigration attorneys, but it's Sam's talking about really giving your full faith and best efforts to your employer. That can really cause problems for you.
Yeah, and that's the law, by the way. This is not like we're not talking common law. This is a traditional master-servant relationship. Employment is a traditional common law relationship where you're required to dedicate all your time. Now, if there's full disclosure on both sides, then you're perfectly okay.
Yeah.
If there's no full disclosure and they're not aware, eventually somebody might call you and say, hey, the $120,000 I paid you for the last 20 months or so, I just found out you were working for somebody else. I'd like to get half of it back. And they can make a good case for it. But anyways, next question.
Well, this question continues a little bit, and I think it's an interesting one. So I'm going to let it ride here. So while I'm working full time with an IT company, can I work for another non-IT full time or non-IT part time job during the weekends, holidays, or after my other job working hours?
The answer is simply yes.
Yes. Yeah. I mean, there's a question, Sam, of how long have you had your green card? Because as long as you're,
he's still working full time for the first employer.
Well, there you go. I mean, part of the whole employment-based green card process is you are supposed to take a permanent full-time position with, the company that petitioned for you, but you've taken that
for a reasonable period of time.
Yeah, for a reasonable period of time. So, let's see. I just happened to stumble past this one. Aren't they doing 9K per week in the last 6 to 8 weeks? So that's got to refer to USCIS's case approval numbers. Yes.
Well, 9K a week. So I got 2 weeks until the fiscal year closes. That's 18,000. All right. So yeah.
Yeah. I mean.
Okay. Well, I like that. I mean, I like what they keep it up. So
that's my beef. It's I don't want them doing it just at the end of the fiscal year. I'd like them doing that through the entire fiscal year, so there's avoiding wastage.
If they can do 9K a week today, why can they not do 9K a week every week?
Yeah. And
that takes care of it, right?
Anecdotally, we are seeing.
And I'm sorry, Brian.
No, you're fine.
Because I'm self-employed. I work long.
I work for a guy named Sam Shihab.
Well, you're soon to be partner, so you're definitely going to have a taste of that. But 9,000 a week Why didn't you work 9,000 a week all year? Why now?
Yeah. I mean, I will say anecdotally, they are approving more cases. We get approval notices in the mail, and they are coming in up more and more. I've been to a bunch of USCIS interviews lately. They're bringing in people for interviews. They're approving cases, but I don't think.
Wait, stop wasting time, man.
I don't think there's a number they could say they're doing short of all of them that would make me happy.
Hey, but at the end of the day, I mean, okay, so you worked hard and you wasted 75, 80,000 green cards.
I am sympathetic to an understaffed agency in the COVID world, but then my immigration lawyer brain turns on and I say, but I want those green cards. I want those green cards.
It takes here's the statistics. It takes 80 minutes to process an adjustment of status application. According to USCIS, 80 minutes, not even 2 hours, an hour and a half to approve one. You should have done 9K a lot longer than in the last 6 to 8 weeks. But next question. Thanks for the information.
Yeah. I like this question because it starts on a positive note. Hi, Sam. My husband got a green card today.
Yay!
Yeah, exactly. He's working for the same employer who sponsored him for the green card. Is there a problem if he submits I-9 form for re-verification with his employer after 2 months?
No. Here's the explanation. So no problem. Explanation. The I-9 is the employer's obligation.
Yeah.
It is not your obligation. The employer dropped the ball just a little bit. They need to fix it and don't backdate it. That's the most important thing.
Oh, that's the employer's responsibility anyway.
For the employer, because nobody wants their employer. They mean the employer.
Yeah, nobody wants to put their employer in a bad spot. I agree.
Right? And supported her husband for a green card. She can give the employer advice. I'm sure they have counsel and they're smart people too. But I'm just throwing that in.
Yeah.
If you see that the certification is backdated to 2 months back, just tell them don't do that. Don't backdate it. It's okay, because if there is an audit and they find out that you're 2 months behind, there could be a $50 penalty or $100 penalty, or okay, we made note of it, don't do it again. Yeah. But if they find out that it's a forgery if you backdate because you sign it under oath, then that's a criminal penalty. Yeah. And nobody wants to get in trouble.
Yeah, I mean, the reason why, I think one thing people fail to understand about I-9 is they don't take those forms and send them to USCIS when they complete them. Though they hang out in the company's records, and it's obviously in the event the potential for fines and warnings you discussed, Sam, they can be audited by the government and to make sure they're in I-9 compliance. But again, these forms sit in your employer's drawers, aren't sent off to USCIS immediately. And for your perspective, it's
and USCIS never look at them. It's ICE.
Yeah. Well, yeah. It's those are the folks that come in. But for your perspective, make sure you're always employment authorized in the United States, and your employer, if they're doing their job right, they'll take care of it on their end.
Yes.
So
6:58. We will able to take maybe a couple more if we move quickly.
Yeah. So EB2 is projected to go ahead of EB3, and it's going and in EB3 it's going back. So would it be? So it would be interesting. So there would be. Well, excuse me. Would they be intersecting somewhere in 2013, or will they push it back earlier than 2012 in the retrogression? So I just earlier in this conversation, Sam, retired from the prediction game. But before I retired, I was talking with you earlier today, and I said there has to be some sort of equilibrium. Eventually, and what drives the categories back and forth is that people people downgrade to EB3 because it's going to be faster there, and then it causes EB2 to move up, and it's presumably if people start jumping back to EB2, EB3 will move again, and they have to stop some. Does it hit equilibrium, Sam?
Well, look at the numbers. The problem started a decade ago when EB3 got backed up and people just two things happen. Number one, people had more experience, and they're able to.
Oh, that's so true. That's so true.
And then now everybody is experienced and they got an EB2. And now they're moving back to EB3. Now they're moving back to EB2. There has to be a better solution.
Yeah. Here's a fun one. From Arun Kumar. Can I take a promotion one level up while the I-485 is pending? Thank you.
The answer is probably.
Yeah.
But you need to talk to an attorney carefully before you take your promotion. And obviously, you should be willing to take that demotion back if USCIS gave you a hard time.
Yeah. I mean, ultimately, if they have asked you the question, your green card is based upon lower role, are you going to be in lower role? And yeah, exactly. Let's keep on going. We said we're going to try to hit a couple more in our last few minutes. So do you believe there's any remote chance of EB3 data filing comes to April 2015 by the end of September 2023? I guess Charlie is hiding in the non-working capacity of USCIS, plus he's trying to be overly defensive. I'm Sam. I'm retired. I'm retired from predictions.
Well, we don't know. We really don't know.
Yeah, I mean, we can think about where it's at right now, and where's it at? Where's EB3 dates for filing to April 2015. I mean, they got it close, Sam. They got it close. They got to January 2015 and October 2020. Ultimately, I think it's got to take more time of, we have a new dump of visas available October 1st. And then that's going to make, in theory, that's going to get some people out of the queue. And maybe if they get enough of those approved, they think about moving forward again. But April 2015 is quite a bit away off of current right now. The final action dates or the dates for filing for EB2 are 8th of January 2014. It's called EB3 or 8th of January 2014. So that's quite the stretch at this point. Yeah.
We'll take the last one.
I'm gonna do a bit of spin the wheel, scroll my mouse down a little bit, and pick somebody at random here. And here it is, Sam. So I see medical interfiling working at NBC and TSC, but not yet in Nebraska Service Center. Have you seen the medical interfiling get attached to I-45 in your experience?
We attended the local office presentation, I think, yesterday, and they seem to have no problem with it.
Yeah, I mean, we have sent medical interfilings, and they're not coming back. So remains to be seen. Yeah, I mean, and typically, if USCIS doesn't know what to do with correspondence, they will send it right back to you in the mail with a little letter saying, "No, thank you, we don't want it." So it's really it's something that seems to work. Well, Sam, we have hit the end of our designated time. Any sort of closing thoughts for us?
No, I mean, be patient. We'll keep you updated. And next week, I think we're going to talk about labor certifications. Maybe invite your younger associates and friends. We thought maybe we just jump into the beginning of the process and explain to you how to turbocharge your labor certification, some of the secrets, and how to be successful at it, and how you can become. We had a really good presentation planned, and then we said we saw Charles Oppenheim's, we knew he was going to be live, and we said it's just too perfect, and well, here we are. Yep. So I think we'll close it out. I think thanks everybody. Always a pleasure. Have a lovely evening. We'll see you next week. Take care, guys.